that people are fearful and scared about coming to work. Investigator has made these recommendations as being and the reports to be credible. We will be determining whether or not the committee agrees with this, and at this point, looking at what, if any, recommendations that we will move forward. Recommendations that has come from the report, from the reporter, is that immediate measures shall be taken to ensure that the Capitol is free from threats of or actual violence and intimidation.
You're full of it.
Recommends, also she recommended that not allowing Senator Boquist access to the workplace based on his statements from June 19th until the legislative branch can determine that Senator Boquist will not carry out or incite others to carry out the violence suggested in those statements within the workplace toward the branch investigating those reports. So today, I want to make certain everyone understands that today's hearing is to determine whether or not Senator Boquist violated, is not to determine whether or not Senator Boquist violated Rule 27, but instead to determine whether or not the Senate should impose restrictions or conditions on Senator Boquist while to allow for the workplace to be safe and free from any type of allegations of based on fear or threatened violence in the workplace. Today's hearing is not a judicial or court proceeding, but instead is a legislative committee hearing. The committee will, in fact, be taking invited testimony. We will provide Senator Boquist the opportunity to address the committee if he would like to, as to posing any current threat of violence in the workplace that would cause Senator Boquist to be denied access to the Capitol. There will potentially be a work session today that will be determined as we go through this process, and at that point, if we are, we'll be considering some suggested motions, potentially alternative motions, and also whatever other matters that we want to take up. I do want to put on the record as well two things. First of all, I have had conversations with Senator Boquist since the Conduct Committee was posted to have this hearing. During that time, at one point, I used the term complaint when I probably should have been using the term reports. As I stated in an email to him, I'm not real familiar with the employment law area. My practice of law as a prosecutor is criminal law. So I more than likely misused the term complaints when it should have been the term reports. I believe that, in fact, has caused some people some confusion. So I wanted to put set the record straight. The last thing I want to put on the record is the delay in the hearing date of today. These statements were, in fact, made on June 19th. For most of individuals in this room probably know that there was a protest within the Senate where Republican members left the following day for about 9 to 10 days, and then by the time we got back and finished our work was on June 29th and June 30th, and so this was the first opportunity, being today's, to get all of the committee members together to be able to go forward. So with that, I wanted to see if anyone has any opening statements for the committee. Senator Olson? No, sir. Senator Manning? All right. All right, now at this point, what we're going to do is the formality, and that is organizing our meeting, and we have a set of, do we have the, okay, so I'm going to ask for Senator Knopp if you'll make a motion on the adoption of the Senate Special Committee on Conduct interim rules.
Mr. Chair, I move to adopt the Senate Special Committee on Conduct 2019-2020 interim rules.
All right, Senator Knopp moves for the adoption of the Senate Special Committee on Conduct 2019-20 interim rules. Is there any questions? Any objections? So ordered. Now, at this point, what we're going to do is open up for our public hearing. As I said, this will be, as noted, it will be invited testimony. And at this point, I think we'll ask for, and I'm not sure if we want Jessica Neely to come up with Brenda Burkgard, our I'm not sure how we wanted to proceed on that. Brenda, why don't you just go ahead and come on up? So we're going to start with Ms. Bongard's testimony, and I want to thank you for being here. If you'll be so kind to put your name on the record, and then I think it would be best is for you to start off as an overview and giving us a context of how your firm, Stoll Reeves, became involved in this matter.
Thank you. Good morning, Chair Brzezinski, members of the committee. For the record, my name is Brenda Baumgart. I'm a partner at the Stoll Reeves firm in Portland, Oregon. Thank you for inviting me to speak with you this morning. How I became involved in this matter is in March of this year, my firm was contracted by the branch to serve as an outside investigator to handle matters with respect to Personnel Rule 27. That contract is in public record. It was effective March 25th, 2019, and that sets forth the scope of my firm's services, including my services to the branch. In essence, I have been retained as outside counsel, and that's the capacity in which I serve before you today and the role that I undertook when I issued my June 25th memorandum.
All right.
The contract, I just want to point out, Chair Brzezinski and members, that it talks about the scope of services, and this is on page 2 and 3, that the role of myself and my firm shall be with respect to assessment, to assist the branch with assessing matters, concerns, or complaints brought forward by employees under Rule 27, evaluation of those concerns in which we are called upon to exercise our expertise and our judgment and our experience in consultation with the branch, and then finally, should there be a need for a formal investigation under Rule 27, we would serve that role as an outside investigator, issue a formal finding and recommendation.
Okay, thank you. And did you have reason to issue a what's titled confidential memorandum to Jessica Nealing and Dexter Johnson dated June 25th?
I did, Chair Brzezinski, and would you like me to speak to the impetus for that?
Yes, my understanding, just for the record, regarding Senator Boquist / interim finding and recommendations.
Correct. So my memo is, as you referenced, is dated June 25th, 2019. I'm hopeful that that speaks for itself. On about June 19th, I began receiving reports with respect to the senator's comments that the chair referenced earlier on the Senate floor, directed to President Courtney, and then shortly thereafter to the media. The reports, as I understood them, were continuing to come in somewhat of a flurry. They included reports from appointing authorities who have an obligation to report concerns that conduct may violate Rule 27, concerns from staff, and concerns from members. My immediate response to the branch as outside counsel was, excuse me, what steps is the branch taking to ensure that these threats will not be carried out in the workplace, and or that employees are not continuing to be subjected to an intimidating, hostile, or perceived unsafe workplace while this is ongoing. So in the course of that, I saw it fit to issue this interim finding and recommendation that pointed out the egregiousness of the conduct. My findings were based purely on those two public statements. I reviewed personally the statements made by Senator Boquist on the floor of the Senate. I watched that on OLIS. I reviewed the statements to KGW reporter Pat Doris, and those were the facts on which I relied upon to make this recommendation. I would also add that my recommendation would be the same whether or not I found a facial violation of Rule 27. This investigation is ongoing. I did issue an interim finding because I do believe that those statements on their face run afoul of Rule 27, which is quite broad, and talks about preventing a work environment that is unsafe, intimidating, and hostile. Workplace harassment under Rule 27 is defined more broadly than unlawful harassment under ORS 659A. And my recommendation would be the same. I would also add that my recommendation, I understand that we're dealing with a different set of circumstances here in the public setting. And And with respect to the conduct of a sitting senator, he does have certain First Amendment rights. I'm not here to speak about those, that's not my role. But in taking a step back and looking at the obligation of the branch to ensure that its employees, members of the branch, members of the public who walk through these doors every day are not going to be subjected to a workplace that is where they feel there are threats of violence or that is intimidating or unsafe. That is the immediate cause for concern that resulted in my June 25th memorandum.
All right. Do you have anything else you'd like to add at this time? I'm going to open up for questions.
I would just add that that really in any workplace is a standard operating procedure, that if there are reported threats of violence, or even less, oftentimes if there are reports of threatened retaliation, that it is prudent for the employer to take an interim step, which is not disciplinary. It is merely to band-aid the situation to ensure that the employer has an opportunity to look into the concerns that are raised, to reach conclusions about them, and then to take prompt remedial measures to ensure that this conduct isn't either carried out in the workplace or that it curbs that conduct. So if I understand we have a unique situation here and there are other factors in play, but if we are looking at this through the lens of what an employer is obligated to do under the law, under Rule 27, the branch has this obligation just the same, I believe.
All right, thank you. That clarification, let me just start with that, because since we're on that subject, it's my understanding that based on other issues of conduct, not including, not representing Senator Boquist, but prior issues that have occurred in this building, there had been a bully agreement and settlement in the Jeff Cruz matter, and at that point, my understanding, the bully did in fact identify us as a legislative branch to be basically an equivalent of an employer and having the same duties and obligations as a private employer would have in their workplace.
I think that's correct, Senator, and that certainly is part of the backdrop with which I approach my obligations to the branch today, coming out of that bully settlement, ensuring that there is compliance with that and that there is compliance with Rule 27.
All right, thank you. I'm open up for questions from Ms. Bungard. First, Senator Manning had his hand up first, then we'll come to Senator.
Thank you, Mr. Chair. I'm glad to be here this morning. I just a general question. I think you had mentioned that there were other complaints without identifying who complained or anything. What was the number of complaints, if that's permissible?
So Chair Brzezinski, Senator Manning, and members, I would answer it this way. I think that given the ongoing nature of this investigation, and I would say that I am at the outset of the intake procedure, I am continuing to receive reports. I have not yet made an evaluation whether those are formal or informal under Rule 27, whether one or more of them will proceed with me conducting a formal outside investigation. If that is the case, of course, the protocol of Rule 27 will be followed. Senator Boquist at some point would be entitled to those formal complaints. He, of course, will, I will invite a meeting with him to discuss those. I mean, that process will be followed. At this point, I would say, I don't know that I can give you an exact number, but there are multiple. And the concerns also are beyond these statements. There are other concerns that are being raised as well, but I think for purposes of protecting the integrity of the investigation, that's probably as comfortable as I am going today, unless of course the committee would like to hear more. Trying to balance those interests and maintain the integrity of the investigation for both the senator and those involved in bringing the concerns forward.
Right, thank you. Senator Camille?
Thank you, Mr. Chair. I have multiple questions. So Brenda, as you engaged in looking at these statements, did you interview Senator Boquist?
Mr. Chair and Senator Knope, I did not. I certainly thought about that because that is typically a normal process. Before there is a finding or certainly a conclusion of the investigation, it is a normal process, of course, to interview the individual about whose behavior is at issue. I did not hear solely because I made my recommendation, my finding and my recommendation based solely on those public statements, which I found to be irrefutable. And frankly, and one thing I should point out, this is about the effect on the recipient's intent in these sorts of employment situations, whether or not a hostile or intimidating workplace is created. The intent of the actor, if you will, doesn't drive that inquiry. It's the effect on the recipients, and both the law and Rule 27 talk about the perspective of the reasonable person. So from my review of those two statements on the Senate floor and then to KGW reporter, I believe those sufficient, and my recommendation is based solely on those facts.
Yes.
Thank you, Mr. Chair. Brenda, there is no formal complaint currently, is that correct?
Mr. Chair and Senator, a formal complaint, if we are talking about in terms of Rule 27.6, I have not yet done an intake procedure and made a determination that a complaint is elevated to the formal level that the individual would like to proceed down that road. We certainly have complaints, reports, if you will, that may evolve into that. I think what's important is that when I issued the June 25th memorandum, it was not linked to any informal or formal complaint. It was based on reports, some of which just came orally to me.
Thank you, Mr. Chair. So Brenda, the reports that came to you, did the Oregon State Police or the Senate President, were they part of those reports? Did they make reports in this case?
I did not receive any reports from Oregon State Police. I'm aware generally, and I think after the issuance of my memorandum, that they did have some communication, obviously, with the branch. They were undertaking their own assessment of the threat to the branch. They were involved, but I have not had any direct communication or received any reports from the Oregon State Police. And the same, I believe, from the Senate President's office. I saw some public, I think 2 public memorandums issued, one jointly by President Courtney and Speaker Kotek, and then another memorandum from the branch.
Thank you.
Thank you.
Senator Olson.
Thank you very much, Mr. Chair, and thank you very much for the opening comments. It's a pleasure to be here. Ms. Bongard, in your June 25th memorandum, you state on their face they constitute credible threats of violence. Is that your opinion or is that fact?
I think my opinion primarily, although I think both, Senator, and I want to be clear, I'm not a criminal lawyer. I'm not making an assessment whether or not these threats in combination or on their own rose to some level of criminal behavior. That's not my scope. What I mean by credible threats is this is not a situation of a he said, she said. For example, I did not receive this information that someone reported that Senator Boquist had made these statements or had where we have a secondhand information. These were statements that I observed that he made publicly. So from my perspective, from the employment perspective, that where you have an employee of the branch who has gone on record publicly and made these statements, and at least by the time I had issued my memorandum, and I think currently as we sit here today, those have not been recanted. That was the basis of my use of the term credible threats there, Senator.
Yes, thank you. So I really want to be clear, this was your opinion that this was a credible threat?
I think I said it's both. I think it's my opinion in my role as an outside investigator, retained employment attorney for the branch to look into concerns brought under Rule 27. And I think that I guess I would follow that with when viewing the statements as they were made, I think on their face they are credible threats, factually.
Follow? Yes, thank you very much. You also state that these threats of violence directly have caused members and branch employees to report concerns, and I quote this from your memorandum. But you stated that you don't know how many members there are and what branch employees. So are we a little bit premature being here if your report and your investigation is not complete? Since we don't know the number of members, you stated that there has been no formal complaint. So are we a little bit premature being here?
Chair Brzezinski, Senator Olson, I don't think we're premature at all. And in fact, I think if we could have all been having this conversation on June 20th, that would have been in the best interest of the branch from the risk perspective where I sit. The point about this recommendation is that, and I would do this the same for any client, for any employer, if reports are brought forward by employees that they have a concern about the safety and well-being of themselves or others in the workplace, whether those are threats based on threats of violence, whether they are threats of intimidation, whether they are threats of retaliation, it is incumbent upon the employer to evaluate what, if any, steps it must take immediately to ensure that these employees are not further subjected to this while it has the opportunity to look into it and reach some conclusions and then decide what, if any, steps it will take. So I'd say we are not premature because I believe, as Senator Brzezinski set forth at the outset of the meeting, that my understanding of our purposes here today is not to explore. This is an interim finding. The investigation is ongoing. At some point, I expect we will be back together and talking about a formal finding or recommendation. But until that point, I would urge the branch to focus on the recommendation, what steps it sees fit to take to ensure that it may maintain a intimidation-free and safe work environment while this investigation is concluded.
Yes, thank you. Thank you for the latitude. I appreciate it. It's interesting that your statement is correct. We need to have a harassment-free workplace. We need to have an environment where we can all certainly work and not be afraid to be here. But it concerns me that this action is moving forward with respect to Senator Boquist and his statements, but yet you can't tell us who has brought in a complaint or who has told you that they have concerns. And that bothers me in the fact that we are moving an issue forward without a statutory statement from anyone stating that I'm concerned. And I don't see that in your report. You just state that violence had caused members and branch employees to report concerns. Now, that being said, we should be able to ask those members what their concern is. Was it a concern of violence? Was it a concern that we'd have more state police in the building? What exactly was the concern? So we're moving this issue forward without full documentation, without full evidentiary evidence to sustain what we're going to talk about. Can you talk to that?
Yes, Mr. Chair and Senator Olson and members, I'm happy to speak more about this. One is I don't view this situation and particularly our discussion here today and why we're here as we are not, the investigation has not been concluded. And I don't believe this type of situation would be in the best interest of the branch to wait a month or two from now until that is done, where you can have the full report as to who raised concerns. I think that this type of situation is grave, it is egregious, it is serious, it is one that puts the branch at risk if it does not look at this from where you sit today and decide what, if any, interim measures need to be taken to, again, ensure that employees are not continued to be subjected to an intimidating or unsafe work environment. I would also add, because I hear in your question the concern, who is the individual? What might their motivations be, if that's really what you're getting at? And again, that will be vetted in the investigation. And to the extent that that these are somehow not credible reports, that will be vetted, but I don't think that will be the case. And let me follow that by saying, even without any employee reports, let's assume for a moment that these statements were made on the Senate floor and then shortly thereafter to the reporter, and no employee came forward, no appointing authority, no employee came forward. Why might that be? Their concern for their own safety, they're concerned about retaliation, my recommendation would be the exact same. The branch knows now, it has reason to know that there could be threats of violence carried out in its workplace, that it could be maintaining a workplace that is subjecting employees to intimidation and fear. My recommendation would be the exact same. So I'd encourage the committee not to focus on the who or the what or the why, but on the comments made and the obligation of the branch as the employer to take interim steps to make sure that its workplace is safe and free of intimidation. I hope that answers your question.
Can I just follow up on that, the last part? During the investigation, would you add that to your statement in the sense of taking steps that are reasonable and necessary during this investigation that's broader than this interim step that you've brought to us?
Chair Poznanski, is your question, are there other recommendations?
No, I just, in the sense of what my understanding is and what I'm trying to ensure is that we're here today to determine what, if any, interim steps we need to take as a body to ensure a workplace that's free of intimidation and threats. And that's based on ongoing investigation that you're doing now, that you, at some point you're going to make determinations as to whether the reports that you received are going to move forward as either informal or formal complaints.
Correct.
But while you're doing that, there still is a need for the employer, in this case the legislative branch, to ensure the workplace is free of those concerns.
Yes, I think that is correct. And again, this is a fairly common interim measure for employers to take. This is not something out of the blue. This is really a no-brainer in these kinds of situations. And that is, to the extent there have been these allegations, in order to ensure that the integrity of the investigation, in order to ensure that employees are not subjected to further fear for their safety, a workplace that they perceive to be intimidating or harassing. These are common steps that are taken to put the alleged, the person whose conduct is at issue, to put them out on an administrative leave. And I understand that has other implications here. And certainly when I was evaluating this in or around the time the comments were made and before making my recommendation, some of the questions I had is, my concern is really about protecting the workplace. And I'm not making an opinion about whether Senator Boquist would be allowed to continue to do his job or not, and so if what fashion. Some of the questions I pose, might he be able to continue to vote or do other things, but just remotely? So this is, again, a very common situation. I understand the overlay here makes it more difficult, but that is not a reason for the branch not to act. And I would just add that the other, sort of what is the risk to the branch, apart from the obvious, to the extent there are, threats of violence. I think we can all understand that, but some more nuanced employment threats, if the branch does not consider and take reasonable steps to ensure that it will maintain a safe and harassment-free workplace during this period. Employment concerns. Are employees still coming to work, and are they working in an environment where they believe they are subjected to a stressful workplace, a hostile workplace, an intimidating workplace? Those can and do result in workers' compensation claims. There is opportunities then for further risk of retaliation, those sorts of things. So those are general concerns employers have in these situations where there has been an issue that has been brought to the forefront. There's a process by which it needs to be vetted, and before those conclusions are made, sometimes there needs to be interim steps taken.
Thank you, Senator Olson.
Thank you, Mr. Chair. Since we're not in session any longer, the absence of all senators, does that relieve some of the tension in the workplace?
Mr. Chair, Senator Olson, I think that's a fair question. I think it probably does, to an extent, take away some of the immediate concern, apart from if the Senate was in session and Senator Boquist was going to be walking on the floor. But I don't view it as something that should be dispositive of this committee or the Senate's decision with respect to this matter. I mean, it's a bit fortuitous, if you will, that time has passed, but the threats are the same, and I would encourage this committee to consider them and what steps it may take in response. The same as if we were having this discussion on June 20th and the session was still ongoing. And that is because the statements are made, the investigation needs to proceed, and I don't believe they become any less serious due to the passage of time. And I would couple that with, I don't believe I have seen, at least at the time I issued my June 25th memorandum, and to the present, a statement by Senator Boquist that would somehow express remorse, recant these statements, provide other assurances in that respect. That might, again, I don't think that would be dispositive. That might be some factors that you would take into consideration.
Yes. Thank you very much. That being said, in an everyday workplace, not per se the Capitol, but in an everyday workplace, if a derogatory statement or a reflective statement against a boss or some other employee were made, and that boss or employee just shrugged it off, would you in fact do the same process you're doing now, saying that this man made or woman made a report or made a statement against the person and they don't care, they didn't make a report against it, they didn't say it offended them? Would you in fact, as an attorney for this type of thing, would you in fact do an investigation on that statement?
Mr. Chair, Senator Olson, I think that's a fair question. It would depend on the facts and circumstances, but oftentimes we see that in the employment setting where the recipient of the conduct or the comment, maybe they have thicker skin, they don't want to become involved, they don't want to bring the report forward. An employer, if it knows or has reason to know of conduct that either violates its rules or policies or rises to the level of violating the law, would have the same obligation to look into those concerns.
Let me just follow up on that. So what I'm hearing, it's not a subjective test of what the individual recipient is feeling or takes in. It's a reasonable person test, I believe you made reference to, as to the workplace, as to whether a reasonable person in a similar situation could fear as violence, threats, or whatever within the workplace.
Yes, Mr. Chair, it really is under Oregon law, and I think is set forth in Rule 27. It is a reasonable person test, right? It's not every slight in the employment setting that's going to rise to the level of a full stop investigation or someone being disciplined or anything like that. But the law looks at the reasonable person test as a balance between objective and subjective factors, with the reasonable person in that employee's situation given power differentials, someone's race, someone's ethnicity, someone's gender, depending on the type of allegations. Would they believe or find these conditions to be sufficiently severe or pervasive to alter the terms and conditions of their workplace? That's how we look at that, for example, in a hostile work environment setting.
All right.
I do have other questions, but I'll wait for someone else.
Senator Cano.
Thank you, Mr. Chair. Brenda, you state in your report, accordingly, and given the gravity of the situation as pertains to threats of violence in the workplace, can you tell me from the two statements where there is threats of violence in the workplace?
Yes, Mr. Chair, Senator Knope, from my perspective, the first statement, which was made on the Senate floor and directed to the Senate President, that I think the statement was along the lines of, "Hell's coming to visit you personally." Given where that statement was made, the breadth of it. Again, I'm not an investigator with the Oregon State Police. I'm not a criminal lawyer, but from an employment setting, you have staff sitting on the dais, you have other members, you have public coming in and out of the workplace. That to me is a threat that is made in the workplace and pertains to the workplace.
Follow-up?
Yes.
Brenda, I believe you said that you did not interview Senator Boquist, so how can you determine what his definition of hell is coming to visit you personally means?
Mr. Chair, Senator Knope, I did not interview him, that is correct, and I made no attempt to make any finding of what he meant by that. I just went purely off the public statement made. And in this case, we did have reports that that statement, as well as a statement to the Oregon State Police, were causing employees to report concern about coming to work at the Capitol and fear for their safety and the safety of others.
Mr. Chair.
Yes.
So, it's my understanding, and I believe I saw Senator Boquist apologize for that statement on the floor where you were then.
I did watch, Mr. Chair, Senator Knope, yes, I did watch, I think, the whole segment on OLIS, and what I recall, and I probably won't get it verbatim, was an apology to the Senate President, but not to the remainder of the members.
Well, was his statement not directed at the Senate President?
Mr. Chair, Senator Knope, I think the statement speaks for itself. And I think that it speaks for itself. I don't need to make any interpretation about the statement. I purely relied on that statement. I watched the statement. I watched the entirety of the statement.
So Brenda, in your report says a statement on the Senate floor directed to President Courtney, correct?
Are you referring to the first bullet point?
Mm-hmm.
Yes, that is what it says.
Okay. Thank you.
Senator Manning.
Thank you, Mr. Chair. My experience in the workplace, I have time, first of all, make a comment, and then I have a couple of questions. I've known that employers or employees that have come into certain types of activities where the employer thought it best that they be removed from the premises pending an investigation. Not uncommon. I don't think that this is one of those things that is not uncommon. When you look at the gravity of what we're looking at, there was an indication that says that since we are out of session, there are no senators in the building. There are employees that are still here in the building, and not knowing who all may have made a report or claim, there is a possibility that some of those same people will still be moving in the building, and perhaps there is a opportunity for interaction contact, which would put us back in that same place that you had mentioned, unhealthy, uneasy, or whatever the case may be, and we may be subject to, under those circumstances, if nothing is done and contact is, even though people have made reports, informal, informal, to be determined, and something does happen, we don't know. What is the liability of this body? What is our responsibility to do nothing?
Thank you, Mr. Chair, Senator Manning. That is exactly the concern I had in reaching out to the branch and issuing this memorandum. The worst position for the branch, knowing, in light of these statements and following them, and knowing that employees had expressed concern, is to do nothing. On the risk, of course, which is everyone's hope that this is not the case, but it does happen in some employment settings, and there are a couple of reported cases in Oregon. If the branch does nothing and knows or has reason to know about these threats or concerns, there is risk for negligent retention, wrongful death, all sorts of claims. There could be statutory employment claims, like I mentioned, workers' comp claims, retaliation, those sorts of things. So there is an obligation upon the branch to act, and that really is the legal position from which I was coming. That as outside counsel, I believed it incumbent upon me to advise the branch of these risks.
So based on the Boley findings that we got, that were against talking about workplace harassment, sexual harassment, all these things, would this also fall up under that report in terms of saying that there was an incident that happened, and apparently the legislators didn't move fast enough or did nothing, and we are kind of, sort of, in a similar situation. I think there was a fine that was paid out. Would this undress, doing nothing, would this also fall up under a violation of that Boley report?
Senator Manning, that is a very good question. I have reviewed the Boley settlement conciliation agreement. I don't know that I'm in a position to to give you my opinion about that, but I would share that I think that is coming on the heels of the Boley settlement and the other issues that the branch addressed at the beginning of the session. I think it is prudent to keep that in mind when evaluating the situation. While this is different, absolutely, but the same sorts of thoughts and concerns, I think, would be important to keep in mind here, but I don't know that I'm in a position sitting here right at the moment to give an opinion one way or the other, whether or not it would run the risk of violating that conciliation agreement, but I certainly think the conciliation agreement is important to keep in mind in this situation.
Mr. Chair, is there a way that we can get some kind of how LC or a legal opinion what the Bowley report does if something's similar to this, just hypothetically speaking, what that would look like, what our responsibilities would be? Is that practical, is that doable, or maybe it's something that I need to look at myself?
Senator Manning, clearly you can make that request. There is a kind of unique situation here based on what I remember and I've taken from the Bowley settlement agreement as to maybe some limitations on the Legislative Council as to how they advise and interpret for the branch in this specific area. Ms. Baumgart is actually our special attorney who's been brought in to give the independence from Legislative Council. So that request, more than likely, if we were moving forward on that, would be for me to turn to Ms. Baumgart and say, ask her to provide us with that. That's, I think, the steps that would need to be taken for that to occur.
I'd really like to hear that.
All right. All right. First, any other follow-up? Senator Olson.
Thank you. Thank you once again for the latitude. Ma'am, you're familiar with the Oregon Constitution, correct? You're familiar with Article 4, Section 9?
Mr. Chair, Senator Olson, I am generally familiar with our Oregon Constitution. I'm generally familiar that there are certainly rights that senators and other public officials in this state have. I do not have that provision in front of me at the moment.
Which is fine. I just get to the point. It states in Article 4, Section 9 that nor shall a member for words uttered in debate in either house be questioned in any other place. The statement that Senator Boquist made was in debate in the chamber on the floor. So my assumption to the Constitution and relating to it that the second half of the concern, the call brought to President Attorney, would not be allowed because it was in debate. So I would think that we would only be dealing with one issue then with the Oregon State Police. Am I incorrect in that assumption?
Mr. Chair, Senator Olson, I believe it is outside the scope of my relationship with the branch and also my expertise to give you a constitutional opinion as to whether or not Sarah Boquist's statement, either all of it or a portion of it, was an exercise in free speech. I think that is something I just think that's outside the scope. My concern and my recommendation was we have threats of violence in the workplace. We have reports of employees feeling intimidated. I think ultimately if there is a finding recommendation that would be part of the process, but there are certain types of speech and threats of violence that do go outside of the First Amendment protections. I'm not here in any capacity to render an opinion one way or the other on that.
Follow up? Yes, thank you very much. I appreciate your comment on that, but on the floor we sometimes get heated. I was chastised because I used the word hypocrisy. And I thought it was a very legitimate term to use, but I was chastised for the fact that it perhaps could impugn my colleagues, and I would never want to do that because we all take this job very seriously. We try to do the best we can, and one person's opinion shouldn't outweigh another person's opinion. So we try to avoid getting into those conflicts. But in the fact, it is a fact that in the Constitution it says those words uttered in debate, and it's exactly what we were doing. We were debating issues. We were talking. One could lay on a definition of hell brought down on you, whether that rises to the occasion of a threat. I find it difficult to believe, but once again, it's uttered in debate. We've argued many times. I've been here 8 years, and Senator Brzezinski and I have gone round and round many times on different issues. But the fact is that since this was sincerely directed at the president, the other 29 of us, or at that time 28 of us, did not receive that wrath. It wasn't directed at us. And the senator certainly did apologize in the debate, and I repeat, in the debate that was taking place on the floor. So my conclusion would be that since it was on the floor and we were in debate, that this particular report or non-report, since the president did not report, be removed from this action. And then when one speaks to the second action on the OSP, it was made in this building, but it was directed if they came to his home in the Dalles. So my question is, how does that relate back to this building then, other than the fact that he was a senator and stated it in this building?
Mr. Chair, Senator Olson, again, I'm not here to opine on the constitutional analysis, but I would not look at it that narrowly. When we're talking about threats in the workplace or conduct that may be intimidating to employees, I think we need to look more broadly versus just, the statement was directed to President Courtney, for example. There are employees who sit up with President Courtney. There are employees who walk in and out of the chamber. There are other senators present. The reports that I received, which I found to be credible, are if he's willing to threaten the president of the Senate, if he's willing to threaten the Oregon State Police, what will stop him from hiring? So
Mr. Chair,
Hang on 1 second. Everyone that's here, you're here to be observing. If you have comments that you want to make, you're going to need to leave the room. One thing I will not tolerate is having individuals make comments from the gallery while we're ongoing with this investigation. We're glad that you're here, but please respect our rules. Thank you.
Mr. Chair, I object to that statement because it's an assertion predicated on your own, what's the term I want to use? On your own decision that you made as a credible threat. Now you're passing on this assertion that he could possibly do something else in the workplace, and that's not right because this is not a court of law, and what you're saying is your own opinion and it's hearsay.
All right, so this isn't a court of law, and we shouldn't be treating the witness as if
I appreciate that, but she can't be making statements on the record like that.
She can. That's her statements, that's her position as to her as being our counsel. And you can accept it or not accept it, but that is what she's here to tell us as to our perspective.
Then I challenge that statement because it's an assumption she's making.
That's fine. All right, let me just follow up on a couple of things. First of all, regarding the addressing of the president, our rules do in fact require that an individual member not address an individual member on the floor directly. All comments have to go through the podium, through the president. And so there has been situations and individuals have said to me as to were those statements really directed to the president exclusively, or did they also include other members? So that's one of those things I think we all have to take into consideration in the context. I believe all of us were on the floor at the time as to what and how we would interpret that. Now, the other thing I want to, I guess, ask more of a broader perspective. In your work as counsel for employment in the employment law area, do you believe that an elected official, because of their position, would have immunity through the First Amendment to be able to make statements that would be perceived in other areas of employment that could be considered intimidating, threatening individuals in the workplace?
Chair Brzezinski, I think that's a very nuanced legal question as to the constitutional issue. And again, my opinion is not on that. I'm not here. But I will say from an employment perspective, looking at this stage, we are at the beginning. We are at the, this is an A to Z investigation. We are at the outset. That it is, that there needs to be a balancing of interests. And when the branch has the knowledge that it has, and all we're looking at is an interim recommendation and steps to ensure the integrity of the investigation. steps to ensure that the workplace here at the Capitol is free from, threats of intimidation. That's all we're looking at, and I would think that that would warrant the same kind of evaluation, and in a way, and setting aside for a moment First Amendment immunity, those constitutional issues which are very important. If we're looking at this and comparing the senator to the CEO of an organization, a private organization, if these comments were made by a CEO, undeniably that CEO would be put out on leave pending investigation, and if these prove true, would be fired. And I view, I guess if we're looking at the pecking order here at the Capitol, that certainly a senator, a sitting senator, an elected public official in Oregon, there's a heightened level of obligation. Certainly in a regular employment setting, supervisors, managers, and certainly executives of the organization are held to higher account, usually by the employer and law. And I would view that similarly here.
All right. Other questions?
Just real quick, Mr. Chair, thank you so much. Ms. Baumgart, thank you so much. What I'm hearing from you is that based off the evidence, well, let me take that back, evidence, based off the findings from the information, that's the only thing that I have been receiving from you, what you have interpreted as potential or violation of Rule 27. Now, when we talk about on the floor, things that we see on the floor that is uninhibited, things like that, I would say that it depends on who's saying it, because there was a case where I made a statement on the floor, and later on, a colleague read it back from a news article. So I don't think that is the proper use of that. If you can't do it for all, then you shouldn't claim it for any. So I want to just make sure that we were on it, that I got that out there. This is not a court of law. And then we're looking at hearing a inquiry. Your report back thus far. I want to commend you for the work that you've done, and I know that we've got a long ways to go. So I just want to put that out on the record, because it seems to be at times things that are being directed at you that's kind of trying to mischaracterize what you're saying. There's a term for that called gaslighting. So I want you to stay focused and continue on unbiased and just go where the evidence leads us to. Thank you.
Olson?
Yeah, thank you. One more question, please. If, hypothetically, Senator Boquist and Senator Courtney were at Magoo's having a beer, and
Local watering hole.
I went to Willamette undergrad in law school, so I'm aware of Magoo's.
There we go. Say they were having a beer together, and Senator Boquist looks at Senator Courtney and says, "If you do that, hell's going to come down on you." Would that be a workplace violation? As considering the fact that the bar was always filled and other people would have heard it.
Chair Pozansky, Senator Olson, it depends. I would not liken that situation to what happened here. And if two colleagues are out having a beer and having words, I think that we would be unlikely finding ourselves having this conversation. But that's not what occurred here.
Follow up then. If Senator Boquist had published that or tweeted that out, that hell would come down on you, would that make it different? Would that make it a workplace violation?
Mr. Chair, Senator Olson, so the same statement tweeted versus made on the Senate floor, I think I would have the same concern to the extent it reached. The mode of communication is not necessarily dispositive, right? I mean, the threats can come via email, they can be through social media, as we often see these days quite commonly, or they can be face-to-face.
Thank you.
Senator Bell.
Thank you, Brenda. You stated earlier that you did not receive reports from the Senate President or from Oregon State Police. Did you interview the Senate President or the Oregon State Police in your in issuing your report?
Chair Przanski, Senator Knope, no, I did not interview either the Oregon State Police or President Courtney.
So, Brenda, my understanding is that what you base this on is on basically what some people say on the face of the document or the statements themselves that were recorded on video that you reviewed, and you solely, exclusively came to us in your capacity as our legal counsel for employment situations and ensuring that we were aware that these two statements that were made, one on the floor and one outside of the chamber within a couple of hours, caused you concerns for the potential risk to the branch, liability issue, as well as the safety of those who are working within the building, some who brought reports to you, others who may not have.
Chair Przanski, that is the correct summary.
All right.
Mr. Chair.
Yes.
Yeah, I've got another one.
Another last one?
Yeah, another last one.
Okay.
Because you talked about in your statement, in your memorandum, you said that have caused members and branch employees to report concerns. Were those reports reported to superiors, or were they directed to you, or were they written and documented, or were they undocumented and just verbally passed along?
Chair Przanski, Senator Olson, it was a combination, except I did not receive any reports to me directly at the time between June 19th when the statements were made and the issuance of my memorandum. They were some oral reports, some email reports, some by appointing authorities. My understanding, staff had come to them, so they were fulfilling their obligation, what they saw under Rule 27, to pass it along, and then some were directly from staff or other members expressing their own individual concerns.
Follow for clarification, they were not directed to you, they were given to other people, and then they verbally communicated them to you. Is that correct?
Chair Przanski, Senator Olson, it is correct that no reports were sent directly to me. They were either communicated orally or passed on via email.
Senator Matt.
Mr. Chair, I noticed that when the talk of this committee getting together, you and I spoke one-on-one briefly, just saying that there is a chance that this committee will come about. I've not spoken with anyone else since that one time that we spoke. I know, I think I'm aware that you may have spoken to each one of us individually about what the committee is going to be pulled for, what it's going to be designed for. My question is that how many, if any, have had this conversation prior to the committee meeting with Senator Boquist?
Are you asking the members that are here who have had contact with him?
And talked about this committee.
As I stated on the record at the beginning, Senator Boquist and I believe we had two conversations that were direct. One was on the 30th of June, at which point I wanted to ensure that he had the notice of the posting of the hearing, as well as the two documents that went up, which was the confidential memorandum that we've referred to today, as well as a cover letter, or I should say cover email that's dated the same date, June 25th, that came out with legislative administration. And at that point, and then since then, I believe Senator Boquist and I have had one other telephone conversation. I forget the date. I don't have that in front of me. And then there has been some correspondence by email. What I wanted to ensure, as I stated at the beginning, that this is not a conduct, formal or informal, not that we'd have the informal in front of us, complaint, but was a report, and that's where I wanted to correct the record, because when I was in his office on the 30th, I unfortunately used the term complaint, and I should have technically been using the term report. And so there's been some communication between myself and Senator Boquist by email clarifying some different perspectives that each of us shared with each other. That's all that I've had. So I'm not sure if the other members want to come in. I will also say Senator Knope and I spoke once together on the floor. I believe it was on the 30th. prior to me speaking with Senator Boquist. And Senator Olson and I have not had any direct conversation regarding this topic since his appointment by the President.
And just follow up, just listening to the types of questions that are being presented, I would really be interested to understand if the rest of the committee has had direct conversation with Senator Boquist regarding this prior to his meeting today.
Absolutely not. I have not talked to him. I've gotten all my information off of OMAS. It's right here in front of me. All the referrals, anything that I have is off of OMAS, and I have not talked to him.
Yeah, Mr. Chair, Senator Manning, I have not had any contact with Senator Boquist.
All right. All right. If there's no other questions for our council.
Sure. May I just clarify one point, because I don't want there to be any misstatement or inference to the earlier question by Senator Olson about the scope that caused some comments from the gallery. I was not issuing my opinion in any way, shape, or form as to what I have no opinion as to what Senator Boquist, whether he would act upon these or not. God, we hope not. My point was what employees have reported. So I don't want there to be any confusion when I mentioned that employees had reported concern that if these statements were made by him in public to the Senate President and to the Oregon State Police, the concern was for their own safety. If he would make those statements, that was my point. And I just want to make sure that the record is clear, that I'm not rendering any opinion as to whether those employee fears are valid or not. I'm just purely stating those are some of the facts I had for considerations when I mentioned their employee reports. Those were some of the reports I was receiving.
So let me just follow up on that. I mean, I think that the thing that's difficult for many individuals is that we're having a mix of different types of law and perspectives and expectations in the employment area, which is, again, new to me, I think new to many of us as to what our obligations and requirements are. There are overlays as to the need for bringing forward, as you did as counsel, to the employer, which would be us, the risk that we have by not taking action based on individuals who are within that workplace that could be subject to these type of fears, concerns, and potential acts.
Sure.
Yes.
I am not a lawyer. Make it clear. I do watch Perry Mason. He's cool. I like him. I'm not a lawyer, but the comment that the attorney just made, God, I hope not. If this was a court of law, I would have objected because you were implying bias by putting that in there. And I would have objected to the court and let the judge be the decision. But this is not a court of law. But I just would hope that you eliminate, I mean, you're supposed to be a neutral arbiter. I would hope you would eliminate all of that and go down the line like you're supposed to and find what's true and what's not true. I find it discerning that you don't have the number of reports or any reports whatsoever to tell us about, other than the fact that someone said that they're concerned.
So I think that, again, we're starting to mix stuff again. I mean, the bottom line is this: what's happening on the complaints themselves, if they're going to come forward, will be judged on those days at the time we get them. To try to bring in and bootstrap in stuff that's being under investigation into what I call an interim step based on the attorney saying we are at risk if we do not take action based on these two threats that were made in those and the venues that were made.
I agree. So what is our goal? What is the goal of this committee today?
The goal
You
is
say we're going to do a work session, but what are we going to work on?
The goal is to determine what, if any, other steps do we have as, and I say we as a committee, to the legislative branch to actually take action to ensure the safety of individuals within the workplace while the investigation on the potential complaints are going forward. In other words, we, based on what she's given to us, the statements that were that are not in doubt because they're videotaped, put out a concern to, as we heard, sorry, I didn't write that term down. I'm going to say the managers, individuals such as members, staff for the members, the legislative branch employees who work within this workplace, meaning the state capitol, as to whether we should be looking at any type of steps to ensure the workplace is free of those concerns during the period of the investigation, and whether there is a need at this point. And I think it's very fair to say we now have a number of days that have passed since those statements were made on the 19th of June. And so those are factors that we need to take into consideration. Clearly, council has told us it doesn't matter per se when they were said, but in the context of what was there and what steps have or haven't been taken. And that's part of the stuff that we'll be talking about.
Well, Mr. Chair, for clarity, the council has mentioned the concerns from employees and reports, but we don't see the reports. So I'm concerned that, well, where are they? We're taking actions against someone without physical documents stating that I feel concerned about this, and I made that report to my superior, and my superior has since passed that on to you. That report should be available to us to see what exactly their concern was.
Mr. Chair, may I address that briefly?
Yeah.
Mr. Nelson, and I think I said this earlier, but if not, I really want to underscore, my recommendation would be the same whether I had a physical email in my hand or not, whether it was 2 employees or 15 employees. My recommendation is based on public statements that were made and the risk that the branch has if it doesn't address those. That's it. I understand there is I understand where you're coming from as far as wanting to know more information about the reports, and that is why we have the investigatory process. But my recommendation would be absolutely the same, even if no employee came forward with a formal or informal report.
Yeah, my understanding and what I would take away from this is that your interim memorandum to us is based on, again, public statements that were made. They're not in dispute, and it's the context of what was said in the context of ensuring a workplace that's free of threat of violence, intimidation, or retaliation.
That is correct, Chair Przonski.
Any other comments? Thank you very much. I assume that you will be here if the committee chooses to ask you to come back up.
Yes, I will remain. Thank you very much. Thank you.
All right. So at this point, and knowing what the context of what our mission is at this point as to determining what, if any, interim steps that we should be taking based on this confidential memorandum report, again, regarding Senator Brian Boquist, interim finding and recommendations dated June 25th of this year. The chair is going to give Senator Boquist the opportunity, if he'd like to come forward, to make any statements that he'd like to make to us, as well as potentially answering any questions.
Thank you, Mr. Chair. Senator Brzezinski, senators, citizens present. First, let me thank the Oregon State Troopers for their service and professionalism over the last 2 months. Whether Kate Brown or Peter Courtney issued troopers an illegal order will now be determined in a court of law. Second, let me thank the at-will staff and the Oregon Legislative Assembly for their service and professionalism in the face of employee abuse, sexual harassment, retribution that they've faced since last year, to a complete failure of the Senate leadership. Third, now to the alleged employment or political hearing today. Senator Brzezinski was kind enough last Sunday to visit me in my Capitol office, handed me 3 pages of what he knew at the time. A draft agenda, a letter signed by Ms. Baumgart of Stoll Reeves, 1 page of it. He did provide a second page later. And that's a photocopy problem. It's not the good senators, okay? And a memo signed by Ms. Nealing that also identified Mr. Johnson, Dexter Johnson, legislative counsel, as well participating. That is just about the total sum of the due process, or my knowledge of Senator Courtney's intent to this proceeding and his tasking to the good chair. This formal public record outlines these facts that will now be used again in a court of law. Fourth, last week my wife, staff, and I initiated formal complaints against the Oregon State Senate with the appropriate federal civil authorities. Fifth, on Friday, I filed a lawsuit in the civil court against the Honorable Peter Courtney, and many of those involved today are listed in the lawsuit. None of you gentlemen, except my apologies, Mr. Chair, for our conversation. The civil court action will be amended after this alleged hearing today or whatever is today. Appropriate legal service has been executed. I have asked the Oregon Department of Justice to provide myself and the court the name of the attorney who will represent the majority in the Oregon State Senate, or will the Attorney General recuse themselves from defending Senator Cornyn as they have in past harassment complaints. All inquiries and questions regarding this political or employment matter will be submitted through your court-recognized lawyer from this point forward. We are now formally in a court of law. Lastly, for the public record, for a long time, Oregon State Police Superintendent, Marion County District Attorney, other district attorneys, federal authorities, and other legal authorities know full well I have offered full cooperation in any legal, probable cause law enforcement action, any judge-ordered action, in any civil matter. I look forward to seeing this matter in the court. Thank you. Gentlemen, have a good day.
And at this point, you do not want to entertain any questions, just for the record.
I believe, Mr. Chairman, you are an attorney and you have counsel here and you know how the court proceeding works. Thank you. There'll be no questions. Thank you.
The public hearing portion of our hearing today, so I'm going to go ahead and close the public hearing. And at this point,
So I guess that's it.
work session regarding this morning's public hearing, so we'll open up the work session. And colleagues, the staff have prepared 3 possible motions for us to consider, not saying any of them will fit or do what any of us might want to do individually or what we might want to do as a group. There's also, as I handed out to each of you, an alternative motion 1, which I've put together based on my review of information that has come to me regarding this, and kind of a hybrid of one of the motions that was suggested for consideration by the staff for us to look at. So what I'd like to do is to open it up for, as I said, work session for individuals to maybe express where they're at instead of trying to run through motions, because first of all, I assume like most of these motions that they're new to you as individuals, and so I want you to have an opportunity to review them. And so I think what I would like to do is to start with I'm going to start with Senator Manning as to your perspective based on the information that you've heard this morning. What, if any, steps do you believe that we need to be taking as a committee as it pertains to us making any recommendations regarding the report that we received? Remember, our task today is not to be looking at the actual substance and merits of any report that has been made as to it becoming a complaint or action as a complaint, formal or informal, but instead, as Council has directed us during her testimony as employers, that the legislative branch does in fact have a duty to maintain and provide a workplace that's free of threats of violence and intimidation. And so with that, Senator Manning, would you like to kind of go through where you might be and what your thoughts are regarding moving forward, if anything?
Thank you, Mr. Chair. This is a really avoidable, in my opinion, incident that we're here right now. And I got to say that I've spoken with a number of staffers and even some of the people that run the building here day to day. And they have expressed to me, openly that they are really concerned, and a number of them, to include some of our Senate colleagues, have expressed concerns that this would not only feeling that they might be under threat of physical, but also mental threat because of all the events that led up to this point. And so I think where I am right now, I am going to side on what I feel is best for the staff and our colleagues. I think that there need to be some restrictions, whether we have escorts by OSP or whether or not the senator decides that he would just stay away until this thing just is resolved. I think those are two acceptable options for me at this time. I did receive a text message from another Senate colleague because everybody's watching this. And I want to be very careful in how I say this, but people find the threats very credible. They are nervous. And it doesn't look good for us not to do anything. Again, my position right now is that a best case scenario for me would be that the senator will say that, hey, I will stay away until whatever this thing is and it blows out, then we can come back, have another conversation. Or if we can't get that, we would have to have some kind of safeguard for the people that work here in this building. And I understand that this is a very, very serious thing. Had I made those comments, I believe that I would have been drugged out of the Capitol at a minimum. I think that when you try to downplay incredible threats that he didn't mean that. When I heard it, he meant that. So I think that in fairness for everybody, those would be two options right now that I see based off of the information that we are looking at. And again, he was very direct when he said, send bachelors and make sure that they're heavy armed. There is no other interpretation of that, no matter how we try to gaslight it. Thank you, Mr. Chair.
Senator Olson.
This committee's kind of in a tough place. We're asked to adjudicate or make a decision on something which we really don't have all the facts on, other than the fact that there were statements made. I imagine all of us at some time or another has made a statement in the heat of passion that wasn't quite nice. It didn't quite fit the confines of what normal society deals with. This has been a very difficult session for all of us. It started out with some new rules that we instituted because of a continuing, what's the word I want to use? Environment that people have lived in, and it's been documented, and it became very tenuous, and the pressure is quite palpable. This is a tough one for me because I probably put my foot in my mouth many times also. I would say we must be cognizant of the fact that Senator Boquist is an elected official, and he does have to have the ability to represent his constituents. We can't take that away. I think it would be not in good stead to have the senator come to the Capitol and be protected by an armed guard. I don't think that that is as appropriate at all. I think that since we are now in recess, or if you will, we won't be back to ledge days, I think that maybe we can make some form of agreement that you can conduct your business from your district office and keep the sanctity of the Capitol so that the whole temperature of the building can cool down.
Thank you, Mr. Chair. I find the report interesting and appreciate the presentation we had this morning. I obviously saw the comments that were made by Senator Boquist. Don't agree with those comments. Wouldn't make those comments myself. But one thing that's lacking, and as an employer, when we have incidents where somebody says something, somebody does something as an employee, we interview that person. And as our attorney indicated, that normally does happen, didn't happen in this case, because it was determined that these two statements kind of spoke for themselves. And I don't actually think the statements do speak for themselves, because we have an individual who has spent many years in the military, and we don't know what his frame of mind was as it relates to what he was thinking when he was saying these statements. And I don't believe at this point that there is a threat to anybody in the Capitol. I share an office wall with Senator Boquist. So if anybody ought to be concerned, it should be me. And there are no employees, according to these statements, there are no employees that were threatened here at the Capitol. And so, and the two people who the alleged threats were made to aren't part of the report. And they're not complainants as part of the report. That being Senator President Courtney and New Orleans State Police, as the attorney indicated who made the presentation. So really what we're left with, I think, is kind of an incomplete hearing and facts of the case. And I honestly was hoping to hear more from Senator Boquist than what his statement was. But he clearly is concerned about significant issues, which he expressed in his remarks. And so at this point, I've looked over the recommendations. I can't support the wording of the recommendations as they are, but I could support something that is modified in those recommendations. But at this point, the wording of it, and some of them to me seems to be premature and somewhat prejudicial as it relates to it. If there is going to be a continuing investigation, then I think we need to let that work itself out. Because, as I said, I do not see Senator Boquist as a workplace threat at this time. We are in the interim, and there are very few person-to-person meetings that go on here at this time. And there's very few interactions. And as I said, I share an office wall with Senator Boquist, and all the interactions I've had with him, and we disagree on plenty. I've never felt threatened, and don't feel threatened by his statements as a member.
As the chair, and in my own personal perspective, and looking at the task that we've been given as a committee, the issues that we have before us is based on a report with interim findings and recommendations. What, if any, steps should we be taking? The report does, in fact, reflect, as we've heard in the testimony, that it was based on statements that were videotaped, so they're not in dispute as to what was actually said. One on the floor on June 19th directed, at least directed toward the president based on the context. Whether it extended to other members, I don't know, but it did in fact call out by his name, and that in relationship whether or not if you send the state police out to get me, hell is coming to visit you personally. Without knowing exactly what Senator Boquist meant by that statement, you have to take it at the surface of what it presents. As our counsel stated, the test here is not whether or not something is criminal in action to be a valid threat. We're in a civil setting, and it is within employment law, and within that as to the requirement and duty of the employer to provide a workplace free of violence or threat of violence or intimidation, etc. So in my looking at that, and then looking at the second statement that was made off the floor to the media directed toward the state police as to what we've heard, I'm quotable, so here's the quote: "Send bachelors and come heavily armed. I am not going to be a political prisoner in the state of Oregon." It's just that simple. Now, what we also have had is that shortly after that, which is reflected in posting that's on OLIS, a email that was purportedly from Senator Boquist to a reporter at the Oregonian. When someone had stated that threat was thinly veiled, he made it clear that it was not. And that was, I look at those three things and I come away that the statements that were made by Senator Boquist were in fact credible threats. What I have difficulty though is at this point determining whether or not he still poses a credible threat as he did on the 19th of June. What I want to put on the record and what we've talked about at this point is that we have had situation that has, I think, been modified or has died down in the sense of the angst, anxiety of when that statement was made on the 19th. Council's report to us comes a week later on the 25th of June. Since then, we've had approximately 2 additional weeks that have occurred since there, and there's been no situation of showing and demonstrating that whatever credible threat there were on those statements, which I have stated I believe were in fact credible threats, of those being continued out. When you look at the context of what those statements and when they were made and what they were subject matter of that, we know that that question is now moot. The state police are no longer being requested to bring any of the members who were absent during those 9 days to the Capitol to do their work. And so to me, that is an action, that is something that has happened since then that tells me that I believe that the workplace is okay for the employees to be in. I do want to point out that even though the session is ended, we're in our interim. We do in fact have individuals who are in this building 5 days a week, working their jobs either in district for senators or representatives, as well as the full-time staff of the Legislative Assembly. And so I do feel that those things do need to be taken into consideration. I personally, in looking at these recommendations, I came up with an alternative motion that would basically, one, find that the statements of June 19th to be credible threats, but that there has been, let me get the term here, that the recommendation of council at this point should be modified as to what steps should be taken based on new information, testimony, and clarification that has occurred through not only the hearing today, but what has happened since the incident occurred. So that's where the chair is at. I do not at this point see that continued threat that was made on the 19th to be present today within the Capitol. I do want to clarify, because I've heard members say this, and I think it's important for the rule, for the record to reflect. Our hearing today is not going to the merits of any complaints, and let's say any reports that have been filed that could be turned into a complaint, either a formal complaint that we as a committee would be addressing, or an informal complaint that would go through that internal process for informal complaints. For us to say that we need to have more information before we act on this, merits, who brought it forward, why did they bring it, is missing the point. This whole exercise that we're going through today is to ensure that the workplace is free of intimidation, threats of violence, while that investigation is ongoing, and to ensuring that everyone who comes to this Capitol, either as an employee, as a member, as the public, someone who works in this building as a lobbyist, are all free of workplace intimidation or threats of violence. And so I want to make certain that we realize that at some point, it may be that we will be meeting again to look at some specific conduct that will in fact materialize as a formal complaint. What I know at this point is we don't know when that's going to happen or if that's going to happen, because the investigation's ongoing. So with that, the position I would be taking at this point would be to acknowledge the threats that were made on the 19th to be credible for what they, when they were said and what was stated at the time, and could in fact cause a reasonable person in the workplace to fear for their own safety or safety of others. But at the same time, because of the amount of time that has passed, other factors that have come in play and things that have not come into play, do not believe that any additional steps need to be taken as it pertains to Senator Boquist being in the workplace here at the Capitol. So that's where the chair is at. So at this point, I don't know if anyone wants to make a motion. And then, as I stated, besides the three that were provided to us as reference points by staff, there is the one that I've put together, which basically would move forward the statements I've just made. So let me just see if anyone wants to make any motions. And colleagues, let me just take a break. For those who are here, I know that this is probably something that you've never experienced in the sense of being at a legislative hearing, let alone this type of a hearing. What we're doing at this point is having an open discussion as to what, if any, motions will be made. And for us to take any action within this work session would require a motion to be before us. So with that said, I'm going to entertain any motions from any of the members.
Mr. Chair, if I may, and I will make a motion, but I want to make a comment first. There was a response that went to state of mind, questioning what his state of mind is. I would argue that none of us actually know that. Again, I'm also looking at the chance meeting of someone that may encounter the senator at the same time while the research inquiry is still going on. What would that look at the psychic of their mind? There are people here that have real fear. They have real fear. They have fear of physical and emotional and mental issues with this. So, as I mentioned, that I will make a recommendation that Senator Boquist on his own can elect to stay out of the Capitol until the inquiry is completed, Or you have down here, the suspended rules be temporarily modified to allow the senator to remote participate from a remote location without being in the building. That would be my motion.
All right, so I'm going to try to summarize that and make sure we understand. Your motion, first of all, what I heard was a motion as to going forward as compared to the threats themselves. So let me just take that part. What I understand is that you believe going forward, Senator Boquist should voluntarily not enter the building to perform his work as a senator within the Capitol, but be able to do that from locale, meaning a district office or somewhere else.
Exactly.
And was there something else to that portion of your motion?
The motion about the threats being credible.
Okay.
I find that they are credible. And see, where's the piece that I'll have to come back on that one.
Let me ask for clarification. We have a motion that's somewhat before us now. It sounds like, number one, that the threats that were made on the 19th are credible. Number two, that Senator Boquist should voluntarily not enter the Capitol as a workplace during the pendency of the investigation that is ongoing with the reports. So, Senator, what if he failed to voluntarily participate at the level that you would like for him to do? What would be, where would that take us?
That would take us in looking at some of the senators and staffers. I think that we open the door then to making sure that we have escorts, not maybe for him, but for everybody else.
All right. Well, we do know that there was at least a memorandum by the two leaders of the chambers, the Senate President, as well as the Speaker of the House, ensuring for employees who found themselves in a situation where they thought that their presence within this workplace, the Capitol, in conjunction with Senator Boquist, was a threat, that they could in fact make other accommodations for them doing their work, either outside of this building or maybe in some other location and stuff. So I want to make certain that's also part of this record. So
Then with that, Mr. Chair, that could be a lot of people. We don't know how many. That could be a lot of people. That could be so many people where we couldn't even reach a quorum unless we modify the rules or whatever we're doing. We could see a lot of people, to include staff members. Again, there were multiple reports done. I don't know what that looks like.
Senator Manning, you said quorum, so now I'm hearing you say something about members. Based on what I've heard from our counsel, outside counsel, at this point, whatever investigation is ongoing should be resolved before we would be back in session in February. That's our next scheduled, of course. Clearly, we had a special session called by the governor that would bring members back together. I thought your motion was more based on the needs and desire to ensure a workplace free of these type of threats and violence for staff individuals or others, let's say non-members of individuals.
I think we should include members as well.
Okay. All right. So do you feel that you've got your motion up there?
Yeah, I think you phrased it the right way. I do find the threats credible, and I would ask that, recommend that Senator Boquist on his own elect, and allow the investigation or the inquiry is going on to stay out of the Capitol, or to suspend the rules, to temporarily modify and allow him to participate remotely from district office.
Yeah. So if you're saying having Senator Boquist be able to perform his duties as a senator as it pertains to voting from a different location, I believe that that is not an option. We have had conversations with legislative council regarding that, and that's that as a possibility. And if you remember on the last 2 days of our session, some of the discussions and some of the arrangements that were made to allow for all members to be able to participate without necessarily being on the floor at the same time, but when they voted, they were on the floor to vote. They were not able to vote from remotely. So I just want to make certain you understand that we've pretty well gone down that path as to what legislative council says is permissible.
I completely understand, and but then that only leads me to the aforementioned either the senator on his own elects.
Okay. So let me just summarize. My understanding
Senator
is, number one,
Manning.
that there's two parts of this motion. First is that the threats that were made on June 19th were credible threats. Second, that Senator Boquist should voluntarily stay out of the building until the investigation regarding the reports that are pending have been resolved. And if he fails to do so, then to have some type of requirement of making arrangements with the Capitol for his entry here to ensure that while he's here, others who work within the building or visiting the building or whatever capacity they may be are safe from any type of carrying out of threats. I'm just trying to make sure we know what we're going to be voting on.
Yeah, that's pretty much a summation.
All right, let me ask Senator Olson and Senator Cano, do you understand the motion as it is for a vote? I'm not saying agreeing or anything. I'm just saying I want to know, make sure everyone knows before we call for a vote.
Generally speaking, yes.
All right.
Yeah, generally speaking, yes.
All right. Patsy, why don't you give us a roll call vote, please?
Mr. Chair, does that motion require a second?
No.
Okay, I just want to clarify.
Yeah. No, we're under legislative rules, not parliamentary.
Okay.
Senator Olson,
No.
Senator Manning,
Aye.
Senator Cadeau,
No.
Chair Przanski.
No. Motion fails. Any other motions from any of the members?
Mr. Chair, in reading your, if I may,
Right.
thank you. In reading your three different motions that you have.
All right, let me just clarify. Those three motions are not mine. The only one I take credit for is
Okay.
an alternative
I'm sorry.
motion, not a motion one, not motion two, or motion three. Those came from staff. Let's just make sure that's on the record.
Okay. In reading the motions, then, not yours, I find it difficult to make any definitive obligation against the senator predicated on council's reports, because she didn't interview the OSP, she didn't interview President Courtney, she didn't interview the people that allegedly have made complaints. That concerns me. So, but in reading the motions, I see an area where I think we can come to agreement on, and that would be on motion 1, paragraph 2, where it says, I recommend that Senator Boquist be advised that applicable law and Rule 27 prohibit him from engaging in any retaliation against an employee or a member who may have brought forward or reported concerns, and that Senator Boquist is to refrain from any action or retaliation against any person who participates in the process. I think at this time that paragraph fits perfectly, in my opinion. It allows us to some parameters to work with, but it tells Senator Boquist we don't appreciate the comments, but those people that are concerned about the comments, you must not retaliate against, and you must refrain from any other action of retaliation against anyone who participates. That gives him the heads up that, we're looking at this, but we haven't come to a conclusion yet because the report's not done, so please refrain from anything that would impair or impact any member, public, as you said, public, lobbyist, employee that would be impacted. I think that fits perfectly, gives him the warning that we are watching, but yet still allows people to understand that we see what's going on and we're waiting for the final reports.
All right, discussion on the motion. Let me just ask a couple of questions, Senator Olson, regarding your recommendation, or your motion, excuse me, is basically the boilerplate that's found on all of the various motions as to ensuring that going forward, that Senator Boquist be advised as to the applicable law, Rule 27, for not engaging in any type of retaliatory. Does not appear that your motion would include anything as to making a finding or accepting the finding as to the threats from June 19.
First off, thank you for clarifying that it is on all three motions that aren't yours, by the way. They're from staff. Yes, I think before we make that critical decision, we have to have a completed investigation.
Okay.
That would be my opinion.
All right. Any other questions before we take a vote on this motion?
Mr. Chair, the motion, the actual threats are enshrined in film and tape, whatever media. So there is no question about what Senator said, and you affirmed it. The question comes that was raised about state of mind. That will keep playing over and over again, because when you meet certain people in the building, what is his state of mind? There's an indication about talking about retaliation stuff in there. We don't know what his state of mind will be. This is, I can't support that.
Okay. All right. Why don't we go ahead and take a vote on this, Patsy?
Senator Olson,
Yes?
Senator Manning,
Nay.
Senator Cano,
Aye.
Chair Przonski,
No. Motion fails. I'd like to go ahead and make a motion at this point, and this would be a motion that we accept the findings of the outside counsel that Senator Boquist's statements on June 19th constituted credible threats of violence directed at the state president and the Oregon State Police. I further recommend that we reject the recommendations of outside counsel based on new information and testimony clarifying that Senator Boquist does not currently pose a threat to staff, public, or members of the Capitol. And that I further recommend that Senator Boquist be advised that applicable law, Rule 27, prohibit him from engaging in any retaliation against any employee or member who may have brought forward or reported concerns, and that Senator Boquist is to be refrained from any action of retaliation against any person who participates in the process. That is my motion from the chair, and I will open that up for discussion.
Thank you. I'm going to oppose that particular motion because Senator Boquist was not interviewed during this particular report, call it investigation, what have you. And what we learned is the two people that the threatening comments were made toward were not interviewed, and were also not complainants in the reports. And so, while I do agree that Senator Boquist does not currently pose a threat to staff, the public, or members in the Capitol, I can't go along with the wording that exists in the motion, and so therefore I'm going to be no.
All right, Senator Manning.
Mr. Chair, thank you. while the question is out there whether or not Senator poses a direct threat to members or others here in the building, I would say that right now there are no other members in the building, so that would seem to be true. I'm concerned about what happens when he comes into contact. While it has no retaliation here, again, I didn't bring it up, but it was brought up about his state of mind. I don't know what would send a response. I agree with the 90% of your motion, but that other piece still, having access to the building is going to bother me. I will support this as it brought up, but we're talking about an inquiry that is ongoing. I think that we're trying to rush to a conclusion when the evidence or interviews and stuff are yet to be explored. So this is an interim, for me, this is an interim. How do we make sure that the workplace is safe and people feel comfortable coming to work? Again, while I think that I would prefer the senator say that, hey, I will voluntarily stay out. It's not in this part right now. But I want to make sure we keep that on the record. It is a concern of mine. And, I can, with all of the information that you put out here, I can support this. Any other comments?
Yes.
Senator Olson.
Thank you very much. Thank you. This concerns me that we are rushing to a judgment, and I understand the weight of the argument, and that we have to have a workplace that is free from any intimidation, harassment, et cetera, as we have laid out in Rule 27. I find it interesting that a report is made by the good attorney without interviews, without reports in hand, without documents, that a conclusion was reached. And yes, the statements were probably not appropriate, but other people have made statements that are similar, if not more egregious than these. And I find that we're trying to come to a basis of it's not the punishment's not the term I want to use, but we're trying to come to a level that we can guarantee safety, but we really can't, because we never know when one is going to do something weird or violent. And I'm not saying that Senator Boquist would ever do that. I'm just saying we never know, because it's happened throughout history that people have done things that we never anticipated they would do. But to base a conclusion on an incomplete document or an incomplete report predicated on what I felt was a slight amount of bias, and the fact is that she's an employment attorney, and that that's your job to look to see what's the best thing to do to make sure the workplace is safe. But it jumps to conclusions and casts aspersions and essentially convicts before the final report is done. So I find it difficult to support your motion.
All right. Any other comments? So, just response, Senator Olson, as I've said to other members, I believe that the task that we have now is what, if any, interim steps need to be taken while the investigation is going forward. I would not be in favor of us trying to make some determination as to whether or not there's merits to the underlying reports that have been filed that are currently being investigated. Again, our task for this committee regarding what we have before us is regarding the workplace that we have a duty to ensure is free of violence, threat of violence, and intimidation. And is what I thought, from my perspective, what I've seen, what I've heard, and what I've concluded based on multiple factors. Yes, those threats were credible based on what was said, just on the sheer force of the statements themselves, and that interviews did not need to be taken as to what was said because it's there. At the same time, it also is my belief that because of the amount of time that has passed, the lack of other issues coming forward, knowing that Senator Boquist has been in the building multiple times since this incident back in June 19th, that I do not believe that he poses a current threat as he did back on the 19th of June based when the statements were made. That's why I put it forward in the way I did. So with that, we do have a motion. Is there any other comments? If not, we'll take a vote. Patsy?
Senator Olson?
No.
Senator Manning?
Aye.
Senator Knope? Chair Brzezinski?
The chair votes aye. Motion fails.
Mr. Chair, if I may make a recommendation.
You may.
When We Crazy 11 came back, there was an enormous police presence in our building. My recommendation would be that if Senator Boquist needs to come back to the building to work, that we perhaps bolster our security force for the time that he's in the building for that day to make certain that security and safety would be maintained. And not a security guard that follows him around, but maybe just a couple extra officers to make certain that everybody feels comfortable.
All right. So I'm going to ask the committee to direct themselves to motion 3. I believe what Senator Olson is recommending, it would be something in line with what motion 3 has, but maybe even more of a modification than what it currently says. For those who are not privy to what motion 3 says, I think it's worth putting on the record. This would be a motion that would be made to the chair recommending modifying the recommendations of outside counsel based on new information and testimony as follows. A, require Senator Boquist to give at least 12 hours advance notice in writing to then we fill in the blank, if he intends to be in the Capitol, and limit his access to the following, fill in the blank there, or B, require Senator Boquist to be escorted by the state police to his office and official meetings, or C, that the Senate rules be temporarily modified to allow for remote participation, or D, being a question mark. It continues with the boilerplate language regarding not having retaliation. I will go back and just state that I believe, based on the council's perspective, that we are not able to temporarily modify to allow for remote participation. Now, if we think that is something that we would want to still include in this modified motion, we could ask council to give us a review and opinion on that, which would mean that we would come back to take that up. I would suggest that maybe that portion not be in there, because the reality is we're not in session. There are not votes that need to be taken. The next time that we will be scheduled for any action on the Senate floor will be in September. If there are, and I assume there probably will be, governor's appointments and that need to be ratified by the Senate. So I'm wondering, Senator Olson, looking at that motion 3, if you would be comfortable with the A and B and taking out the C.
I would be more comfortable if, I don't have a problem with allowing us to know he's coming, removing B so that he's not escorted, taking out C, and adding D where bolster OSP force for security reasons.
And then do you think that under A, we have this in there, I'm not saying that's what we should need to go with, at least 12 hours advance notice? Would that time frame be within your motion, or do you think something else?
I think it would be appropriate to bring in another couple officers,
Okay.
and I'd ask the rest of the committee if they thought it was also. But I think that it would be appropriate that he, and I would personally say that we don't send it to President Courtney. I think we might send it to the Secretary of the Senate so that she's aware of that he's coming in, and would not limit his access. I wouldn't limit his access to the building because we have extra security in the building.
All right, and so basically regarding that portion, this is advance notice in writing, which could mean email as well as.
Right,
I just want to make sure we've got the record clear. And you're thinking to the Secretary of the Senate, do you think that would be appropriate over the Director of the Human Resources Committee? I'm just throwing something out there that's.
Yeah, I think that. I think since it's on the Senate side, I think it would be appropriate for the Secretary of Senate.
I have no problem with that. I just want to make sure we know what we're talking about. Gentlemen, you've heard somewhat of the modification. What if I got this correct? It would be under motion 3, we would take the A, and it would read something to the effect, require Senator Boquist to give at least 12 hours advance notice in writing to the Secretary of the Senate if he intends to be in the Capitol, and limit his access. We wouldn't take out the limiting access.
I would think that should come out because he
Is the next part.
Right.
So that would be there, and then what we would do, and that OSP's presence would be increased. In other words, they would have additional trooper or troopers in the building during the time that Senator Boquist would be in the building.
And then include, once again, that following paragraph.
Yes. Yeah. All right. So I'm going to ask Senator Manning and Senator Canote, you've heard what we've discussed, myself and Senator Olson. Do you have any questions regarding that proposed recommendation? Senator Manning.
The question that I have is Council's recommendation to acknowledge the actual threat is not part of this motion. I think that I have made something similar to this on, looking at how we make sure that people are feeling comfortable in the building. I don't particularly care who the notification comes to. I think that it is a slight when we say that the Senate President shouldn't receive this. He's not the president he's the president of the Senate over everybody. And he's going to have to make a call. So I think that that's something that we need to do away with. I would prefer a report to go to HR, because the Secretary of the Senate is going to have to communicate with the President of the Senate. It makes no sense to me. I think that having, if he's in the building, making sure that we have enhanced OSP, we did that in the past, and I'm okay with that. But just bear in mind that this is not a conclusion. This is just an action to take while the investigation or the inquiry proceeds. And so I don't want to get that lost in this. This is not a conclusion at all.
Yeah. Can I respond to your statement? I personally agree with Senator Olson that I think the Secretary of the Senate would be the appropriate person in this particular situation. This is why. We know that there's ongoing potential litigation ongoing now, as well as, let's say, concerns as to different individuals in the building. Senator Boquist has made it very clear from my discussions with him and my readings of his statements that he does not believe and wants to have contact with HR, specifically Jessica Neely, who is our director. And because there's potential litigation involving her, I don't think that would be the appropriate person that should be receiving the notification. Same thing with the president. I felt that what Senator Olson has suggested is a person who is an officer of the Senate, who is voted by all members to be in that capacity, and she really is kind of our air traffic controller for the business of the Senate. And I think that whenever you enter in anything into the record, into the journals, that's where it's going. So I personally think that Senator Olson is correct, and that's why I would not be as comfortable putting adversarial interest in contact with each other at this stage.
Mr. Chair, I understand what you're saying, but then potentially we can make anybody adversarial. You know, this is shaping the battlefield. I don't have a problem with it. You know, that's fine. We can do that. I can live with that. I'm not going to lose any sleep. But you know, I am concerned again about where we're going with this, and that we don't get distracted from this is the beginning or part of an ongoing inquiry, and we're not coming up with a conclusion. I don't want us to get lost in that.
To me, this is an intervention, is what it really is. It's basically the investigation has been ongoing prior to June 19th. And because of what happened on June 19th, we've been asked to take steps to ensure safety within the workplace. Clearly, this is not goes to any portion of the merits of any of the reports that outside counsel is currently reviewing and potentially would bring forward through the Rule 27 process for processing reports into complaints, either formal or informal.
Mr. Chair, would it be inappropriate to ask counsel if she felt that this would be significant enough to ensure a safe workplace for the time being in the interim?
Sure, we can have Brenda come back up and give her perspective. I mean, to me, I guess what I'm going to say, well, let's hear from her first. I guess what I'm going to say while she's getting situated is it is showing that we have taken all the information that's come before us, and we're taking what we think are reasonable steps at this point to ensure safety within the workplace.
Thank you, Mr. Chair, Senator Olson and members. I agree with some of the comments. It's a difficult position, but one that I think is necessary and is a balance, right, between the senator's ability to do his job and the importance of the branch ensuring safety for the staff, members, the public, et cetera, has been discussed. So I think the issues are being discussed appropriately. It's $1 million question, isn't it? And I think Senator Olson, you said we can never know, right? We can never know. We can't, we only know what we know. And what we know, at least at the time I issued the June 25th memo, is articulated in that memo. And certainly there has been subsequent information. Chair Przonski also referred to what I think has been quoted as a double down statement. Thinly veiled. This is a real threat. So, I think the committee has articulated what the facts are. My only response would be, and then I will answer your question, is I think it's where I sit, I take a step back. And I'm not so focused on, was this a direct communication in the middle of a debate on the Senate floor between Senator Boquist and President Courtney? The way that I need to look at this in advising the branch and that the law looks at it is the effect on the recipients. It's not just what was the intent behind Senator Boquist's statement, how did that affect President Courtney, or how did that affect the Oregon State Police? And that's part of why I did not conduct the interview at the time, because given the urgency, what I believe to be the urgency of the situation, the fact we were not dealing with disputed statements, and the fact that the way the law looks at this is not just the effect on the recipient of the statement or the inappropriate conduct, but on those who are also subjected to that in the workplace. So that is I just want to make that clear for the record too, because I think some of the comments have been struggling with how do we have a finding without an interview or knowing the full reports, and I understand that, but I hope that helps explain where I was coming from. I don't believe I had access to the senator, and even if I did, I think I would issue the same recommendation given what I believe to be an urgency of the timing, given the nature of the threat. So the question is this enough? If you all are comfortable that these steps, this is the question I think you need to ask yourselves and I don't think I can answer for you. Is this sufficient to ensure that the branch has taken prompt, remedial, effective steps to ensure that during the pendency of the investigation, that we are doing what we can to ensure that employees, members, lobbyists, people of the public, anyone who's involved in this in any way as a reporter, as a formal complainant, as a witness, is not going to be subjected to ongoing or additional threats of violence, actual violence, intimidation, or hostile work environment. That is the legal obligation on the branch. I think this is much better than not doing anything. I still feel a little bit differently about the passage of time. I would look at this more as if, I agree, and that is a factor, that we have gone a couple weeks, these have not been acted upon, we are not in active session, that these are factors to consider, but I also don't know that if we're looking at it from the affected employees, particularly the employees' perspective, that passage of time has really changed their level of concern. I am very pleased to see the piece about the non-retaliation, because from a risk perspective to the branch, that is one of the biggest risks. That through the pendency of the investigation, that there could be conduct or comments, and these could be in person, they could be via email, via social media, to the media, that would put the branch at risk, that additional comments or conduct from Senator Boquist or others directed towards participants in the process could further exacerbate the situation. So I'm very pleased to see that statement in there about the non-retaliation. I think that should be taken very, very seriously from, one, it's the right thing to do, but two, from a risk perspective to the branch. That is something you want to keep control over.
All right, thank you.
Mr. Chair, if I may, I might have missed it, but I don't believe Ms. Baumgart put her name on the record for this.
Oh, thank you.
Does she have to again?
Well,
Since she's the only one.
yeah, essentially we've always gone forward, and we're kind of just a continuation. But for the record, if you
For the
please,
record,
okay.
thank you, Mr. Chair. Brenda Baumgart, Stoll Reeves.
Thank
Right.
you.
So the only other thing I'm going to say, I think is worth noting, is that even though some of us would like to have had that ongoing investigation on this interim action to include interviews with Senator Boquist, I think we all know in time, those statements were made on the 19th, on the 20th through up until the 29th. I would say he was not available, let alone probably wasn't interested in an interview to be done because he wasn't here.
Right.
And so that would bring him forward. And of course, your report came to us on the 25th while the walkout was still ongoing. All right, with that, we have a motion before us. I'm just going to recapture it so we make certain we have it correct when we vote. This would be a recommendation to modify the recommendations of outside counsel based on new information and testimony as follows. Require Senator Boquist to give at least 12 hours advance notice in writing to the Secretary of the Senate if he intends to be at the Capitol. That while he is at the Capitol, there would be an increased presence of OSP troopers or officers while Senator Boquist is in the Capitol. Lastly, the recommendation would include that Senator Boquist would be advised that applicable law and Rule 27 prohibit him from engaging in any retaliation against any employee or member who may have brought forward or reported concerns, and that the Senator Boquist is to be refrained from any action or retaliation against any person who participates in this process. That's the motion that's before us. Is it clarity?
Mr. Chair, just one thing for clarification to make certain that it's on the record, and you did this before. In writing could also mean via email.
Yes, it could be electronic writing.
Okay, thank you.
Senator Manning.
You said increase OSP or security presence in the building. Is it in the building or it's on the Senate side? We could have an increase on the House side and would have no effect. So are we talking an increase on the Senate side?
Well, I think the increase has got to be across the building. This workplace involves all individuals. And if Senator Boquist were to say walks across that demarcation of the Senate into the House, some people would say the lower chamber just for whatever, we don't want it to stop there.
Okay.
So I think, does that understand? Clear? All right. All right, I think we now have a motion. I think everyone has any other questions on it. If not, Patsy, why don't you go ahead and call the roll?
Senator Olson?
Yes.
Senator Manning?
Aye.
Senator Knopf?
Aye.
Chair Presensky?
Chair votes aye. Motion passes. All right, so with that, we've, I think, concluded our work as what this committee has been asked to do. I want to thank everyone here as committee members first for your time and effort to make it to the building for this. And for all those who've been participating as observers, I want to thank you for taking time out of your busy day to be here. We hope that this has been a meaningful experience for you as to how our state government works and moving forward on these type of issues. And I hope that you realize that each and every member here has weighted the effort of determining what is the best course for the branch as it pertains to the workplace being free of any threat of violence or intimidation, and that we will not be taking any action at this point regarding any merits of any reports that are currently being investigated. Those will come to us if they come to us at some time in the future. Any other closing comments? Thank you very much. We're adjourned.